in the fire.
Yeah, man.
Hot pants and back James. This night's gonna take you higher. Find the keys in Joe. Talk about David. Take your big band master on straight out of here. You gotta.
Good afternoon, ladies and gentlemen. Welcome back to Money Talks Media, our bi-weekly show dedicated to growing your money in and around the GTA. And we've got our good friend, Maureen Tabuchi. She is a lawyer who practices with wills and estate planning. And we're on the hot topic of will planning. Maureen, so thanks for joining us.
You're welcome, John. Good to be here.
I always find whenever I talk with you, I always pick up some more information. And that's great. So we're talking about wills, and let's talk about wills and estate planning for business owners, because that's a really sort of that's certainly the markets that you and I are involved with. So go ahead. Maybe you could elaborate on some of their requirements.
Definitely. There are some additional elements to being a business owner. The one is having a corporate will, so having a second will. And if you own the shares of a small business corporation, it's something that does not need the certificate of the court in order to be transferred to your heirs. So if you put that in a separate will, just like that, you can avoid probate tax.
So that's why people do it, to avoid probate tax. They have
Yes.
two wills. Now, what is probate tax? I understand it's $15 on every 1,000.
Exactly.
Okay.
It's technically it's 0.5% on the first 50,000.
Yes.
But we just kind of ignore that and just
Yeah.
go by the rule of thumb of 1.5% on your estate.
And they can avoid that with a second sort of a corporate will.
Yes. Yeah, the way it works, John, is you need to probate certain assets. So what we do is we segregate your assets into two different piles. One requires probate, one doesn't require probate. Because if you're going to do a second will, you might as well take full advantage of that.
Right.
So if you have any artwork that's of value, jewelry, put that in the second will as well, because that kind of stuff doesn't require probate.
I understand.
So in the you're going to have the will that's going to be probated. Anything to do with a bank, real estate is going to be in that probate will. In the other will, you're going to have the non-probate assets. So shares of a small business corporation, jewelry, art, personal property. And then also in the non-probate will, which we'll call the corporate will, you can give specific instructions about how that company is going to be run, because the way that most of us run our businesses, I mean, we wish we could clone ourselves, but it's just not possible. There's going to be quite a transition in moving from you as the director of the company to whoever, if your heirs are going to sell the company, if there's someone that's going to step forward and take care of it. So you can have transition clauses in the will as well about what's to be done if something happened to you, in order to continue to keep the value in that company. Because if you've got payables that are piling up, or your database that's dwindling down so quickly, in some businesses, competition is really stringent. So a business that suffers a loss really quickly, you can have clauses in your will to protect that.
That's interesting, because now does that revolve more around buy-sell agreements? And it strikes me that that's kind of the direction you're going in.
Yes.
And it's interesting to hear that a will, I mean, I know it involves obviously the sale of a business to an heir, or the disposition of a business to an heir, but does that, you actually within the will dictate terms of a business within the corporate will? Is that what you're saying?
No.
Okay.
No, I'm not saying that. I'm saying that before they dust off that shareholders agreement with the buy-sell provision, someone's got to take the helms of the business.
Yeah.
And in some businesses, it can basically run itself for a couple of months and there's no concern. But other businesses you need someone to step up to the plate right away.
Okay. And that's obviously a great topic. And I know a lot of business owners are so busy running their businesses that they are not paying any attention to that. I meet them all the time. And you do too, right? Like maybe they have a buy-sell agreement, but it's not properly funded with any type of liquid assets.
Definitely.
Have you come across that? Go ahead.
Yeah, a little bit, John.
Yeah, so you're dealing with them, and I know it's sort of a separate topic, but it is a sore point. I mean, no one expects to die or become disabled, and when it does, and you could be sitting there with your spouse, who knows nothing about your business, with the shares of your company being your partner's new partner.
Right. That's a problem, John. Another problem is a situation where you have a family, and the family is, I mean, a lot of people go into mortgages at over 80% of the value of the property. Their only real asset is the house. So there's maybe a tiny little bit of equity, but people do very elaborate trusts on the education of your children. What's going to fund that education?
Right.
Life insurance is really, really key.
Well, now you're talking my language, because obviously I know you're an advocate of insurance policies. I know we've spoken about that. Maybe you could talk about how that also further plays into a will, the importance of having a properly funded will.
Oh, definitely. Well, I mean, like I just said, when you have a trust that provides for the children, and most trusts, we got into children a little while ago, but most trusts are very well set up if they don't give all of the money in your estate to the kids all at once, right?
Yes.
So often a typical setup that we have is a third of your estate to the children when they reach age 21, a third at 25, and then the remaining third when they're 28, something like that, just to spread it out so that if they get a chunk of change and just go crazy and buy the sports car or whatever, then there's something still left. They get another kick at the can in order to preserve the money that has been left to them. But all of this, John, we always assume that when we're talking about an estate that there is money. So the way that we live nowadays, I mean, I try my best to pay my credit card off every day, but it's tough.
Everything's a fortune.
It's not easy. Yeah. So a lot of us rely on life insurance. And there's nothing wrong with that if you are funded with life insurance. But a lot of times when I'm doing an interview with a client and they're underinsured, which is basically their insurance would not cover off the mortgage on their house, then that means, John, the surviving family would have to leave that house. They'd have to move if they don't have adequate insurance. So now forget about the fancy schmancy education trust that we've set up for the kids. If they have to move and downsize, and can you imagine the hardship?
Yeah, no, I agree with you.
Sounds like I'm kind of plugging life insurance.
Well, no, but I don't think you're saying anything that you don't believe in. Well, you're speaking the truth.
It comes from the heart.
I know it is, because I've delivered these checks, and no one's barking about the premiums when you're delivering a death check. They go, I need it. I got to stay in the house. So your comments are well received, and I know you believe it.
Definitely. So aside from just having a will, that's kind of my, preaching from the pedestal, is make sure that you're well insured. It's worth it.
Okay. Tell me something. Perhaps we could talk a little bit about how someone goes about choosing an executor.
Okay.
And maybe you could elaborate on that. What's the best way to do it?
Definitely. Okay. I just want to say one thing.
Go ahead.
I went to a convention with lawyers a little while ago. Everyone has a different opinion, John.
Go ahead.
So I'm going to give you my opinion, and it's not to say that it's the opinion of the lawyers, because here's my opinion. I think you should choose someone you trust.
Okay.
Someone else might say, choose someone who's got a good head on their shoulders. But to me, that person that you trust they can go out, they can hire a lawyer, they can hire an accountant, they can hire a financial planner to assist them to do what's right and what makes sense from a money perspective. But how many people do you actually trust? Now, some people don't have anyone that they can trust, and then you get into a situation with a financial institution acting as a executor, an administrator of the trust. That's a lot of money when you go that route. But if you do have someone you trust, then that's my advice. And to have backups. So, because you never know. Here's another reason why you should have a will, and just get it today. Like, don't even go to sleep tonight. In fact, a lot of my clients say, I'm going to sleep so well tonight knowing that we have signed the will. But it's so easy, because when you appoint a number of people, that is going to give longevity to the will. You don't have to have your will reviewed every year, every 5 years. I mean, if nothing's changed, a lot of people say it's good to review it. And sure, why not, to make sure that nothing's changed? But a good will is going to outlive you. A good will is going to, last for a long, long, long time, because you're going to appoint someone that you trust as an executor, and then any amount of backups that you can.
Now, do people hire you to be the executor as a lawyer? Have you found yourself in that role?
No. Actually, it's the Law Society doesn't like it.
Okay.
I don't know how to. That's kind of the easy way to put it. They don't recommend it. It's a conflict of interest.
Conflict of interest, yeah.
That along with, you sign your will and now you have to keep the original with me. Like, I always give people a choice, because it's not, lawyers don't draft wills to increase a business, or they don't offer to be executors to increase their, because executors can get paid under the legislation. They can actually, not make money from it, but they can officially be remunerated. And but it's a little bit of a conflict of interest. So you won't see that too often anymore nowadays, John, that the lawyer's the executor.
Okay. Interesting. Okay, we've been talking wills and estate planning with Maureen Tabuchi. We're going to take a quick break. We're going to come back and talk about powers of attorney and some of the living benefits involved with will planning.